Okay, welcome to Housing Protections for Childcare Providers. Today's session is presented by Giani, an attorney with the Childcare Law Center. Before we get started, I want to mention a couple of logistical notes. In order to turn on live captioning, press the button with the CC symbol at the bottom of your screen if you're on a desktop computer. This session will be recorded and will be uploaded to our website within 1 week of this event, and feel free to use the Q&A to ask any questions.
All right. Good afternoon, everyone. Thank you kindly for joining us today for today's training. Again, my name is Giani Interiano Brown. I'm a staff attorney here at the Childcare Law Center. And today I will be presenting on the housing protections for family childcare providers. Before I get started, just a couple of items of housekeeping. Number one is that you can evaluate this training after it is concluded. I've provided an evaluation Google form link in the chat now. For folks who want to give us any feedback on how we can better our training, how you felt after our training, or any additional resources or information you might need, feel free to fill out this training. It'll really help us, and we greatly appreciate it. Another item for folks to think about while we go through today's training is that we have a very helpful email listserv for qualified legal service projects, legal aid attorneys. We only send out about one email a month or so, so if folks want more information on the topic we discussed today or any of our other focus areas, please go ahead and sign up in the chat. Here's the link there. All right, so with that being said, I will do a light introduction of the Childcare Law Center in case folks are unfamiliar with our work. So our mission here at the Childcare Law Center is to educate, advocate, and litigate to make childcare a civil right. The Childcare Law Center is a state bar funded legal support center that is specially funded to support qualified legal services projects or QLSP legal aid organizations. Our work focuses on 3 areas of childcare law. That includes housing rights for California family childcare providers, which is the main topic of today, the subsidy rights of California families in need of childcare subsidies, and the disability rights of children in childcare settings. We also have a part of our work that does legislative advocacy, meaning that on the state and local levels, we advocate for better childcare laws that would increase childcare access for families in California and create a more equitable childcare field for childcare providers that make that industry go round, essentially making sure that they are paid a living wage and that their rights are respected under the law. So as a legal support center, as I mentioned, we're funded to support QLSP organizations. As such, we can provide the following services to you and your team if needed. Number one, we can provide multilingual online resources and publications for both clients and attorneys to use. We pride ourselves on producing accessible material for a variety of audiences, and all of our publications go through a rigorous readability and accessibility protocol just to make it easier for legal staff to digest, but also for folks to use and implement in Know Your Rights trainings or any other community outreach that the resources could be helpful. We can also offer free technical assistance. If you have a puzzling research question you don't have time for, maybe you're even unsure if it falls under one of our focus areas, don't hesitate to reach out to us. You would be surprised what we could assist you on. We've also provided co-counseling on certain housing discrimination cases. Those are cases that could involve a family childcare provider who is a renter or a homeowner, maybe facing discrimination from a housing provider or even an insurance company. We'll go over those, rights and those situations in just a moment. And of course, we have an intake line like most legal aid organizations. And let's say your organization is needing to refer an intake out just because of capacity or maybe focus area. You're welcome to reach out to us directly and refer those intakes to us. Since we're a legal support center, we have a very restrictive, we're only allowed to take very restricted number of cases, but if it's referred to us by a QLSP organization, we can definitely take that on and assist you by being a referral. And finally, we can provide free trainings and in-services to legal staff, as well as your clients or any other communities you work with that you'd find would really benefit from this information. I'd also like to give just some brief examples of what our work has looked like recently for QLSP organizations. One recent example is we've conducted some fair housing testing work with an organization, Project Sentinel, that has really assisted us in understanding what housing discrimination against renters looks like when those renters provide family childcare in their home. With this information, we're really hoping to bolster more awareness around these housing protections, but also make it easier for housing rights advocates, landlord-tenant attorneys to see examples of housing discrimination and understand ways to combat it, which can be really helpful through the testing outcomes. We've also done a lot of legislative advocacy on the state level, supporting the passages of laws that promote equitable childcare for providers and accessible services for families. We often issue support letters, sign on to Me Too's, doing activities such as that. If your organization is trying to uplift a policy change or sponsoring a policy at the state or local level, feel free to reach out if you ever are in need of support or want any consultation around the legislative advocacy process. And of course, recently we've been lucky enough to co-counsel with the organization Housing and Economic Rights Advocates around two housing discrimination lawsuits. We are hoping to test the law that we'll be discussing today in today's training by doing this state court lawsuit with the QLSP organization. If that's something that your organization does and wants support around housing discrimination work in this focus area, please feel free to reach out. Okay, so with that being said, I do want to give people a little context before we dive into the topic of these housing protections for family childcare providers. Number one, I like showing this image. It's an image where we're seeing childcare law as a legal field, but also all of the other topics and focus areas that actually fall under the umbrella of childcare law. So as you can see, there's a variety of legal practices that fit under this umbrella, including landlord-tenant law, family law, criminal law, insurance law, employment law, contracts, disability law, business and tax law, and finally, immigration law. Today, we're going to be focusing on two of the kind of subtopics underneath childcare law, and that would be landlord-tenant law as well as insurance law. Also, I want to note that as a QLSP organization, you might be thinking, well, my focus areas are quite broad. They might not be as niche as the Child Care Law Center, but as you can see by this graphic, you'd be surprised what childcare law can entail, and you're always welcome to reach out to us if you're wanting clarity on what we can assist you on. Okay, so why exactly are we here today talking about these special housing protections for California family childcare providers? And I'd like to show this graphic as well. It's a pie chart that really shows that back in 2021, it was reported that California only had enough licensed childcare facilities to meet 24.7% of the need, leaving 75.3% of families left behind without childcare services. And I know that was back in 2021. That's when the last big survey of these childcare programs was done, but it really just shows that California is facing a severe shortage of childcare programs that not only affects people with children and the children themselves, but just affects all of our local communities and how well our communities can thrive. Because we see that with a lack of childcare, folks are unable to access employment outside of the home. They might be unable to then pay for their necessary living expenses. That further leads to housing insecurity for their families and further economic instability for themselves as well. With childcare access, folks are able to go back to work outside of the home, possibly go back to school, and really take care of themselves and feel supported. So that's why we're here today, because childcare shortages are really intertwined with housing discrimination against family childcare providers. When those providers are unable to access housing because of discrimination, they're no longer able to offer their childcare services to families who need it in their local communities. Okay, so who are we talking about exactly when we say a family childcare provider? Folks might be thinking of their own childcare experiences, whether personally or maybe you yourself are a parent or guardian. But family childcare providers are a very specific group of childcare providers. They're folks who provide licensed childcare from their own home, and that home can be rented or owned. And their childcare program is often referred to as a family childcare home. I want to note that these programs have been called a variety of things throughout the years, but family childcare home is the now more commonly accepted and referenced phrase for these childcare programs. Family childcare providers are really an essential part of our state and national workforce, providing vital support to children, families, and of course, our local communities. Think about our essential workers with night shifts. Perhaps someone who works at a hospital or who does janitorial services at night, anyone that has a night service. This vital workforce often needs childcare that offers a flexible schedule outside of the normal 9 to 5 window. For example, during the COVID-19 pandemic, family childcare homes, with that flexibility in hours and services offered, they were able to serve groups of individuals who worked at hospitals and had a variety of shifts that they needed to cover. And so that made it a really accessible form of childcare for these families. These childcare providers and their family childcare homes are exclusively regulated by the California Department of Social Services Community Care Licensing Division. This division is often just referred to as Community Care Licensing or licensing. There are two types of state family childcare licenses. One is a small license, the other is a large license. With a small license, a family childcare provider can care for up to 8 children, and a large license holder can care for up to 14 children. As you can see, the number of children that folks can care for with this type of childcare license is vastly different than what we think about when we hear, preschool or childcare center, where there might be multiple teachers available at one time and caring for maybe 30 or more children. Family childcare homes are a very small childcare program that at times only has one childcare provider in charge of all the children present. Family childcare providers, of course, must comply with childcare regulations, California Health and Safety Code regulations, as well as the guidance under the Office of the State Fire Marshal, which I'll talk about in a little while. So many parents and guardians prefer family childcare homes because they offer a variety of things. So number one, they offer a nurturing home-like environment. They also offer early morning, evening, and or weekend hours, which can be really helpful for parents and guardians with, schedules that include hours outside of 9 to 5. They're also the primary option for infants and toddlers. As you can imagine, being in someone else's home can be really helpful for a child who is first entering, a childcare program, being with other children. If that setting looks similar to their own home or feels more like a home to them, it might be more welcoming and an easier transition for that child. And finally, family childcare homes often meet the cultural and linguistic needs of children and families. The vast majority of family childcare providers are women and people of color. Many childcare providers are also immigrants, and a majority of family childcare providers in California are bilingual or multilingual. So the majority of these housing protections for these California family childcare providers can be found in the California Child Daycare Facilities Act. This law was first passed some 40 years ago. And at the time, the California legislature wanted to improve childcare licensing by providing a comprehensive quality system for licensing child daycare facilities to ensure a quality childcare environment. In passing the law, the legislature recognized that the lack of childcare was a growing statewide concern, as there was an increasing need for childcare with more parents entering the workforce than ever before. The legislature also wanted to acknowledge that many parents preferred childcare in their own neighborhoods. And the law emphasized that childcare licensing had to be affordable for childcare providers, easy to regulate, and not heavily burdensome. However, even after the Daycare Facilities Act was enacted, childcare providers and advocates began seeing how enforcing this law would be a lot harder than expected. For example, the state did not limit how cities and counties could also regulate family childcare homes on top of what the state was already requiring. So over the years, cities and counties were requiring far more from family childcare providers. At some point, cities and counties were allowed to regulate 4 areas. That's spacing and concentration, so how many children were enrolled in the program, traffic around the childcare program, parking, and the noise of family childcare homes. Childcare providers were reporting that cities were sometimes requiring them to have a certain number of difficult to secure off-street parking spaces. Some city planning departments were even asking them to obtain and include architectural drawings of the inside and outside of their homes with zoning permit applications, and more. These requirements were costing some childcare providers thousands of dollars, and of course varied city to city. So it was really difficult to understand what local regulations would apply to these family childcare providers, depending on where they lived. Something really had to be done to address and potentially eliminate these barriers placed on cities and counties on family childcare providers and their family childcare homes. So the Child Daycare Facilities Act then needed to be updated and clarified to protect family childcare providers from unlawful local regulation, as well as potentially housing discrimination that they were also experiencing. With family childcare providers and advocates, the Child Care Law Center took these issues straight to city councils of individual cities, where family childcare providers educated city council members about their programs and the difficulties they were facing when trying to meet these local requirements. This advocacy work eventually made it to the state level, and in 2019, the Keeping Kids Close to Home Act, also called Senate Bill 234, passed, and it strengthened and clarified housing protections within the original Child Daycare Facilities Act. The Senate Bill 234 amendment intended to decrease costs and increase the availability of family childcare homes, and really address the unnecessary barriers facing family childcare so that family childcare providers could go forward and open their programs, stay open, and care for more children. This law also clamped down on what groups could restrict and regulate family childcare homes, giving family childcare providers more of a peace of mind in running their programs and helped ensure that they were treated with both dignity and respect. Specifically, Senate Bill 234 deemed that licensed family childcare homes were considered a residential use of property rather than a commercial use of property, and interpreted family childcare homes as a use by right under all local laws. It also made sure that family childcare homes could be run in all types of residential settings, not just single-family homes. It also clarified that it is unlawful to refuse to rent to someone solely because they operate a family childcare home. The amendments in Senate Bill 234 also addressed the lack of enforcement mechanism in the original Child Daycare Facilities Act. In response, language was added to say that family childcare providers, as well as applicants who were applying for family childcare licenses with the state, had access to the same remedies and procedures in the Fair Employment and Housing Act, or FEHA, if their rights were violated under the Daycare Facilities Act. This cross-reference to FEHA was a key victory in passing Senate Bill 234, because before this law was passed, lower courts had held that family childcare housing discrimination cases didn't have a cause of action or a violation under the Child Daycare Facilities Act. Rather, family childcare providers would need to establish that they were a part of a protected class and bring claims under other civil rights laws such as UNRRA, FEHA, of course, or the Fair Business Practices Law, which posed extra procedural hurdles for family childcare providers. Now, with this added provision in Senate Bill 234, family childcare providers are now explicitly afforded the remedies and procedures that are offered under FEHA for violations of the Child Daycare Facilities Act. Government Code Section 12980 et sequitur, which is now cross-referenced in the Facilities Act, gives family childcare providers the right to file discrimination claims in Superior Court. Please note that filing claims under the Child Daycare Facilities Act is one option if a tenant is experiencing housing discrimination, because they offer or plan to offer family childcare in their home. They may have other civil rights claims and legal options as well. For example, a source of income claim under FEHA that could allow them to file a CRD complaint, Civil Rights Department complaint, or a state court complaint. Advocates should also be mindful that at present, there is no case law using the Daycare Facilities Act yet in housing discrimination issues. However, it's currently hopefully being tested in court. Okay, so finally, Senate Bill 234 also addressed how local fire departments' regulation of family childcare homes had also differed from city to city, which was also confusing and burdensome on family childcare providers. After the passing of Senate Bill 234, the Office of the State Fire Marshal was required to issue statewide guidance for family childcare providers and keep its code current regarding family childcare homes. This ensured that local fire departments treated family childcare homes similarly throughout the state, and family childcare providers were aware of the fire safety requirements they had to meet when operating in California. Again, it's important to note that this law went into effect right before the COVID-19 pandemic, and many cities and counties were unable to update their ordinances to reflect this new law when it passed in 2020. Even today, unfortunately, many cities and counties still have not updated their ordinances to reflect these new important changes for family childcare homes. This has led to local landlords and others misunderstanding the law and requirements for family childcare homes. This has definitely made enforcing this law difficult, and that much more important that the awareness is spread about these housing protections. So the housing protections for family childcare providers in California fall into three categories. Number one, protections from local government regulations. Number two, landlord-tenant related protections. And finally, number three, insurance-related protections. So in terms of local government regulation, before 2020, family childcare homes were being treated like businesses, having to apply and pay for expensive and burdensome zoning permits and business licenses, and comply with specific rules for family childcare homes only. This made it a lot more expensive to get your family childcare home up and running, inhibiting childcare programs from opening and families getting the local childcare they needed. Now, cities and counties cannot regulate the use of family childcare homes and must treat them like all other residential homes. As a note, rather than local governments regulating family childcare homes, the California Department of Social Services exclusively regulates family childcare homes in California, along with local fire departments. Second, the law states that small and large family childcare homes must be considered a residential use of property and a use by right under all local ordinances, including but not limited to zoning ordinances, rather than being seen as commercial uses of property. In the past, the law had seen family childcare homes as commercial uses under local laws and required providers to follow local requirements like registering as a commercial operation. Cities and counties also cannot require that family childcare providers apply for and receive zoning permits to operate. If a family childcare provider lives in an area zoned for any type of residential use, cities and counties cannot require that family childcare providers get a zoning permit to operate. Cities and counties also cannot require that family childcare homes have a business license as an in-home business operation, even if that business license would be at no cost to the family childcare provider. Again, this is because family childcare homes must already have a license from the state, so a local license is no longer required. Lastly, cities and counties can no longer have specific special rules that only apply to family childcare homes. Additionally, cities and counties can no longer create special requirements for large family childcare homes, so those programs that care for more children in the home, in areas of spacing and concentration, traffic control, parking, and noise control. Like anything, there are exceptions to these local government regulations, these protections around local government regulations. So family childcare providers still must follow local laws that apply to all other residents or all other homes in the provider's zoned area, not just family childcare homes. One common example is a local noise ordinance. If a provider lives in a neighborhood with a local noise ordinance that says folks must be, have quiet hours between the hours of 10 p.m. and 5 a.m., a family childcare provider must still follow that local ordinance because it applies to all residents in their area. Now, if there was only, a noise rule that applied to family childcare homes from the city, that might be something that would be seen as an unlawful government regulation, and a family childcare provider may not need to comply with that outdated law. Family childcare providers must also follow local fire department requirements of large family childcare homes. And of course, family childcare providers must comply with all state health and safety requirements for family childcare homes. So there are some ways that local government, state government can still regulate family childcare homes. Okay, so now we'll shift gears to talk about the second category of housing protections, the landlord-tenant related protections for family childcare providers. Renters can have a family childcare home in a variety of rental properties, so single-family homes, apartments, duplexes, condos, and basically all other multifamily buildings. The only authority that can prohibit a family childcare provider from operating a family childcare home in a certain type of home is community care licensing. Community care licensing inspects every home before giving someone a family childcare license and refers to the square footage requirement for residential homes that can be found in the California Building Code, which requires a certain amount of square footage in a space per child in the program. So basically, there's already someone coming in and telling a family childcare provider that their space is big enough or too small to have a certain number of children in their program. With that being said, the law now includes explicit landlord-tenant protections for family childcare providers, as well as folks who are applying for a family childcare license. The law protects these folks from unlawful conduct by housing providers. And that group of individuals, housing providers, includes landlords, property managers, leasing agents, realtors, homeowners associations, mortgage companies, as well as homeowner insurance companies. Specifically, these housing providers and others cannot refuse to rent to a tenant solely because they have or plan to have a family childcare home. And this includes verbal and written denials. They also cannot regulate, restrict, or prohibit a family childcare home in a rental unit. And this includes prohibiting family childcare homes explicitly or implicitly in lease agreements, special contracts between a renter who discusses that they have a plan to open a family childcare home, special rules that only apply to family childcare providers who are renting, waivers of a renter's rights in exchange for allowing them to go forward and open a family childcare home, even a landlord or other housing provider asking to be included in someone's family childcare home business financially, asking for a cut of their business profits, or even harassing or threatening a renter who has or plans to have a family childcare home. So for example, saying things like, I'm going to sell this rental home if you continue with your family childcare business. I will complain to the city about you, or even making blatant threats like the neighborhood association and I will take you down, things like that. All of those acts are unlawful. Another thing the law does prohibit is it prohibits housing providers from raising a tenant's rent just because they have or plan to have a family childcare home. Raising someone's rent just because they plan to have a family childcare home or they're currently operating a family childcare home is not a valid reason to raise someone's rent under California law. We've seen this done at the rental application stage, when someone tells their prospective landlord, I'm going to operate a family childcare in this rental home. But it can also occur even years later after A tenant tells their landlord, I have a family childcare home, continues to operate, and then eventually the relationship somehow sours and the landlord decides to raise the rent, saying that it was because of the family childcare home. So unfortunately, this does happen in a variety of situations at all different times. We've also seen this as a tactic to harass a tenant into moving out quickly. So for example, saying a landlord or other housing provider saying, I haven't raised your rent in many years. How could you open your business that I don't agree with? For that reason, I'm going to raise your rent even higher than normal because you decided to continue your plan to have a family childcare home. It's important to note that rent increases for all renters, including family childcare providers, have to follow local rent control laws and state rent control protections. Now, family childcare providers do still need to comply with lawful rent increases, just like any other tenant. Some other things that the law prohibits housing providers from doing is raising a tenant's security deposit beyond the legally allowed limit just because that tenant has or plans to have a family childcare home. We've also seen this tactic used to get a tenant to move out or stop their plans to open a family childcare home. A lot of tenants react to someone increasing their security deposit at random as a threat. They feel very nervous. They maybe see it as a first step in what will be, another rent increase. So this is a very common tactic used by housing providers to scare a tenant into closing their family childcare home or just stopping their plan entirely. We will note that it's tricky to advocate around security deposit increases because technically the law says that a security deposit can be raised to the legal limit for all renters when a landlord finds out about the family childcare home. So for example, if the renter tells them of their plan or when the renter moves in. Landlords, unfortunately, do not follow this part of the law. As I mentioned, a lot of times the security deposit increase happens at random. And landlords have often increased the security deposit even years after a tenant has started providing family childcare in their rental home. And unfortunately, this part of the law hasn't been tested in court, but the law itself is quite clear in saying that the security deposit can be raised, but only within the legal limit. And of course, the law does prohibit housing providers like landlords from evicting a tenant just because they have or plan to have a family childcare home. I do want to note that this protection is based in the Health and Safety Code, where the Child Daycare Facilities Act and the amendments in Senate Bill 234 can be found. But it also should be noted that you can cite to the Civil Code's anti-retaliation provision, which prohibits someone from retaliating against another person for exercising a legal right that they have. Now, in the landlord-tenant related protections, we also have protections that apply to homeowners who might be providing family childcare from their own home or renting to someone who does. So these housing protections are quite unique because it can benefit a family childcare provider or even help a family childcare provider who's a renter talk about how their own landlord is protected from discrimination. So specifically regarding homeowners associations or HOAs, HOAs cannot remove a homeowner from an HOA community solely because they have or plan to have a family childcare home or rent to someone who does. Furthermore, regarding the purchase and financing of residential property, realtors, real estate agents, HOAs, mortgage companies, lenders, and others cannot refuse to sell or finance the sale of property solely because the buyer has or plans to have a family childcare home. All right, so now we'll go into the final category of housing protections for California family childcare providers: insurance protections. So childcare liability insurance is not required for the operation of a licensed family childcare home. However, all family childcare providers, either renters or homeowners, must choose between three options when considering liability coverage. They could get traditional childcare liability insurance, they could even get a bond, or they can decide not to get traditional coverage at all and instead inform all the parents and guardians in their childcare program that they do not have liability coverage, that let's say if they're a renter, that the homeowner of the rental property also will not cover any liability arising out of the program, and have parents and guardians sign what's called a parental affidavit form that acknowledges that they know about this and that they're okay with it. So those three options are what a family childcare provider must choose before operating their family childcare home. Now, with that being said, the Child Care Law Center strongly recommends that family childcare providers get childcare liability insurance on their own. This type of policy is separate from residential insurance, like renter's insurance or homeowner's insurance, and it's different than commercial insurance policies that folks might look for when opening a preschool or childcare center. In its prohibition against landlords and others regulating, restricting, or prohibiting family childcare homes, the law also prohibits landlords and others from requiring that renters get childcare liability insurance to run their family childcare home. Of course, that concern comes out of, landlords or other property owners being afraid that liability will be pushed on them if a family childcare provider gets sued by a parent or guardian in their care. But the way that this part of the law is written, homeowners of rental properties that are occupied and rented by a family childcare provider, they will not experience liability arising out of the family childcare home. That onus is taken on by the family childcare provider tenant. The law includes this accommodation because they include that accommodation, the ability to choose one of those three options, not because they want to make it easier for family childcare providers to avoid liability, but really to acknowledge how incredibly difficult it is to not only find a childcare liability insurance policy, but also secure an insurance policy, as insurance companies have been known to unlawfully exclude family childcare homes from coverage. However, if a family childcare provider is a renter and they are considering getting childcare liability insurance, or that liability insurance conversation comes up between them and their housing provider, a landlord, HOA, or other housing provider can request that that family childcare provider add them to the liability insurance policy if these 4 steps are already taken. So number 1, they must be added to the policy if that family childcare provider has or is planning to get childcare liability insurance. Also, that landlord, HOA, or other housing provider must ask to be added to the policy in writing. The policy also has to not be, have some sort of provision that it will be canceled if an additional party is added to the policy. And finally, the housing provider agrees to pay a higher premium amount if there is one to add them to the policy. So these 4 steps must be taken to then be required to add a housing provider to a liability insurance policy. Homeowners are also protected from insurance-related housing discrimination because either they are or they rent to someone who is a family childcare provider. These protections involve homeowner insurance, not childcare liability insurance. So homeowner insurance companies cannot cancel or fail to renew a landlord's or family childcare provider's policy solely because a family childcare home operates on the property. Also, homeowner insurance companies cannot refuse an application for or cancel an insurance policy based on the source of income of the individual or group of individuals residing at the property. So going back to that slide, it's really important to understand that this protection really assist in that conversation where a family child care provider is a renter and they're trying to explain their liability coverage, any liability concerns with their landlord or housing provider. So this protection is really helpful to have because it then protects a homeowner who is renting to a family child care provider. I also want to note that homeowner insurance companies cannot refuse an application for or cancel an insurance policy based on the source of income of the individual or group of individuals residing at the property. Again, this is around source of income discrimination and is just another general protection that can protect someone who is under threat of losing their homeowner insurance policy, perhaps all of a sudden, maybe not given as much notice, solely because they provide or they rent to someone who provides family childcare in the home. So family childcare provider tenants must still do the following, even though these protections are in place. So number one, they must still notify their landlord, HOA, or other housing providers that they will be opening a family childcare home at least 30 days before they open their doors. This is usually done through a basic form that they can find on the California Department of Social Services website. A lot of folks are given a copy of this form when they do licensing orientations, and all it requires is that the family childcare provider complete the form and just deliver a copy to their housing provider. Family childcare provider tenants must also ask for their landlord, housing provider, or the property owner's consent before doing the following. And it's a really specific circumstance. Family childcare providers don't need this type of permission in every situation. If they're a renter, it does not trigger them to have to ask for consent before opening their family childcare home in a rental property. But basically, if a renter is operating a family childcare home, let's say they're operating a small family childcare home, that means that they can care for up to 6 children normally, or up to 8 children with their landlord's consent or permission. So if someone is already caring for 6 children under their small license, and they want to care for 2 additional children over the maximum number of 6 children, that's a situation where they'd have to ask their landlord if they can do so, get that landlord's signature on another Department of Social Services form that says that they give consent before going forward. Now, if the landlord or other housing provider withholds their consent, says, actually, I think you should still care for 6 children rather than 8 children, that family childcare provider tenant does not then have to go forward and close their family childcare home. They don't have to turn away any families that are already in their program. They would just be able to keep caring for 6 children in their program, or even transition into a large license where they could care for up to 12 children without their landlord's permission. Of course, family childcare provider tenants must also follow lawful rent increases and lawful security deposit increases. They must always follow lawful terms of their lease agreements and must follow rules that apply to all tenants in rental properties that, of course, follow landlord-tenant laws, and make sure they follow those rules that apply to everyone in rental property, not just family childcare providers. Okay, so with that being said, we have a few hypothetical questions that I'd like to go through. I'm trying to be mindful of our time. And so I'll go through a couple of them. Folks can either just read along with me or put their, answers in the chat if you want to see if you got your answer correct. Feel free to participate as much as you'd like. So essentially, I like starting off our hypothetical with this individual named John and his wife recently opening a licensed family childcare home to earn extra income while working from home. This is a really common situation where folks are maybe retirement age. They want to pull back from working in an office. They've worked with children for many years, perhaps as a teacher, and want to operate their family childcare home as a way to earn income by working where they live. So, however, John just got a letter from his homeowner's insurance provider. The letter says that John's policy has been canceled because it does not cover childcare facilities. Based on what we learned today, how can John respond? I'll give folks a few seconds to think, kind of mull it over what he might be able to say to his insurance provider who is trying to cancel his policy. Okay, so how can John respond to his insurance company? Well, it's important to think about the law first. So an insurance company cannot cancel a homeowner's insurance policy solely because the policy holder runs a family childcare home on the property or rents to someone who does. So in response, John can inform his insurance provider of the law. Unfortunately, there's a lot of ignorance around these special housing protections. Perhaps his insurance provider is referencing an outdated local law or has no idea that family childcare homes are seen as a residential use of property, and unlike most commercial uses of property in a residential setting. He could also decide that it's too difficult to navigate this with his insurance provider alone and might want to contact an attorney to help him talk to his insurance provider. Because this could impact, obviously involves John's source of income, providing family childcare from his home, he could consider filing a housing discrimination complaint with the Civil Rights Department if he believes that his rights are being discriminated against under FEHA. And finally, since this is insurance related, he's actually able to file an insurance complaint with the California Department of Insurance, who's aware of the insurance related protections and has welcomed people to file complaints with them so that they can also address and monitor discrimination by insurance companies. All right, so now the next hypothetical we have is about Josefina, who's a licensed family childcare provider and just moved into a new rental home. She emails her landlord that she will be opening her family childcare home in 1 month. The day before she opens her doors to families, Josefina's landlord demands that she get a valid business license from the city and apply for and receive a city zoning permit. Based on what we learned today, how can Josefina respond? I'll give folks a couple seconds. If you want to put anything in the chat, any thoughts, concerns that come up, please feel free. All right, so how can Josefina respond? A landlord, number one, cannot require a city business license or zoning permit for their tenant to be able to operate a licensed family childcare home. Again, family childcare providers get a state license from the California Department of Social Services. They no longer need local business licenses. And furthermore, they do not need zoning permits to operate their family childcare homes. And that's because family childcare homes are seen as a residential use of property, not changing any of the uses of, it's not changing the way the family childcare provider is using the residential property. It's seen on par with them solely living in the home with their family. City and county business licenses and zoning permits are, like I said, not required to operate a family childcare home. And in response, Josefina can do the following. They can inform the landlord of the law. Perhaps Josefina's landlord is unaware of what a family childcare home is, might see it as a traditional in-home business operation, and there could be room to just educate the landlord before taking any other legal action. Or depending on the circumstance, perhaps this is a very hostile situation. Perhaps this is also in response to maybe other landlord-tenant conflicts coming up around, let's say, habitability concerns, repairs, things like that. Josefina has the option of contacting an attorney to help her advocate on her behalf with the landlord. All right, so for hypothetical number 3, we have someone named Carissa who's running a small family childcare home from her apartment. One day, Carissa receives an eviction notice from the property owner. The notice demands that she either close her family childcare home or move out. Shocked, she calls her property manager, who responds that the lease agreement clearly prohibits a commercial use of the rental home. How can Carissa respond to this eviction notice? And while folks are thinking about this answer, it's important to think about, what Carissa's goals might be, any risks that Carissa could be facing by, addressing this eviction notice. Perhaps there's some fears that might be coming up for her in what to do next. That can all factor in, what you think Carissa should be doing first. I'll give folks a couple more seconds to think about it until we move on. All right, so how can Carissa respond to this eviction notice? It's important to remember that a licensed family childcare home is not a commercial or business use of property when renting residential property, and it's illegal for a property owner to evict a renter solely because the renter has or plans to have a licensed family childcare home. In response, Carissa can consider the following. Well, number one, she should really be contacting a landlord-tenant attorney immediately to respond to an eviction notice. A lot of folks might consider being, a pro per in housing court, but it could be really beneficial to, advocating for Carissa on her behalf to get a landlord-tenant attorney on her side. She could also decide to share information about the law and her own protections under the law with the property owner as well as the property manager, referencing that even in a lease agreement that prohibits businesses, that would not apply to a licensed family childcare home. And that's because when the state passed the Daycare Facilities Act, as well as the amendments in Senate Bill 234, the legislature wanted to emphasize that family childcare homes should be seen as a residential use of property and should be, alleviated from the burden of, being restricted, regulated, or prohibited in lease agreements. Of course, if, sharing information on her rights doesn't feel helpful, she could also decide to file a housing discrimination complaint against her landlord with the Civil Rights Department if she believes she's being discriminated against under FEHA. Again, that can also be with the assistance of a landlord-tenant attorney. All right, so being mindful of time, we'll do one more hypothetical. This is about Cam, and she's looking for a new home to rent. She submits an application for a single-family rental home. During a phone call with the property owner, Cam shares that she plans to get a family childcare license. She thinks the neighborhood is perfect for her potential business, as it is close to an elementary school. The property owner responds that they cannot rent to Cam as much as they like her as a potential renter. A childcare sounds like too much liability for the owner to handle. How can Cam respond in this situation? So when we're thinking about how Cam can respond, it's important to remember that it's illegal for a landlord to refuse to rent to a prospective renter just because they plan to have or have a licensed family childcare home. And with that being said, Cam can think of the following when deciding on how to respond. She can share information about family childcare and her housing rights with the prospective landlord. We've seen this be a really helpful first step for a lot of prospective renters. Again, there's a lot of ignorance around this part of housing protections for family childcare providers. So sometimes it can just be really helpful to, point out the law to landlords and saying that I am protected from being turned away from renting homes solely because I provide family childcare or plan to provide family childcare. Cam could also volunteer information about which liability coverage option she will be getting when she finally does get licensed. Again, that can be totally up to the renter, how much information that isn't required to be shared they want to share. That could include Cam's own family childcare license number. The law does not require a renter to share their license information with their landlord outside of just notifying their landlord that they will open or asking for permission in that very specific special circumstance. But if that feels helpful, if that might, relieve some concerns that the landlord is having, perhaps they don't think it's a legitimate business or what have you, that might be a renter's choice just to make their life a little easier by sharing information about their license, sharing information about what liability coverage they need and what they're going to get, just to make the conversation go smoothly. CAM could also suggest visiting the Child Care Law Center's Housing Rights webpage so that the landlord can get more information about renting to licensed family child care providers. The Child Care Law Center has a really specific publication that's geared towards landlords to really alleviate a lot of their fears, a lot of common concerns that come up when they are considering or renting to family child care providers. Of course, in any of the hypotheticals presented, that can be a good option as well. And finally, CAM could decide to, again, file a housing discrimination complaint with the Civil Rights Department if she believes she is being discriminated against under FEHA. She could also decide if she, attempts to reach back out to the landlord, educate them, explain her right to provide licensed family child care in rental homes. She could also decide to file a state court complaint if she feels that the landlord is still discriminating against her under the Daycare Facilities Act. Okay, so I've provided a couple more hypotheticals, but there will be answer slides attached to all of these hypotheticals. So since we weren't able to go over them today, folks will still have access to them when they receive the materials for today's training. And while we wrap up today, just want to see if there are any questions or concerns that come up. Please feel free to put them in the chat. And for the last few minutes of today's training, I just want to note that through a lot of information on everyone, and just want to let you know that the Child Care Law Center is here to help. We are always available to answer any questions or concerns that come up in your work that you might be looking for assistance on, any clarifying questions in your advocacy. Had a lot of QLSPs take up family child care provider clients and reach out to us at different stages of their relationship, and that's a really helpful way for us to hear, how it's going with your advocacy around family child care providers, and also helps us make a more robust housing rights program that really meets the needs of QLSP attorneys and their clients. So I want to note a couple of helpful resources that we already have available. We have a great QLSP webpage designed for QLSP attorneys. I've attached it there. We also have a housing rights webpage that recently was updated. We have a new liability insurance publication that can be really helpful for both housing providers and renters, as well as updated information on what Senate Bill 234 did back in 2020 and how it's looking now, as well as publications for tenants who are considering providing family child care from their home or are already doing so and might be facing some issues there, as well as a publication for landlords that educate them on all aspects of family child care and renting to family child care providers. I know our work doesn't only include housing rights. We have a great subsidy rights webpage. So for benefit law attorneys that are watching this training and might want more assistance around working with their client who needs CalWORKs childcare assistance, or even if they're working with maybe immigrant clients who are considering applying for childcare subsidies, that can be a really helpful webpage as a jumping off point. And of course, you can contact us for more information, resources, collaboration, etc. And of course, we also have a disability rights webpage as well with more information there. We are available in a variety of ways. You can email our QLSP program manager. That's my colleague, staff attorney Karina Ligo, at her email there. We're also available by phone at extension 101. And of course, you can directly reach out to us through our intake page that's accessible to laypersons or attorneys on our website. And I just want to say thank you so much to LAAC for having us today for this training, and thank you kindly for all of your attention today. And thank you so much. I look forward to hearing any questions you might have.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.